already. We're live here from Reddy & PC from Houston's office. Along with me is Emily Newman, my business partner.
Thanks for joining us today. If for some reason we're not able to get to your question today or you want further information, you can always set up a consultation with any of our attorneys by going to rnlawgroup.com. And you can always get the latest updates by going to immigrationgirl.com and ask your questions there as well. So what are some of the latest updates that we have as of today?
Emily, on the Friday, the visa bulletin from the USCIS was been released. Visa bulletin from the State Department was been released last week, and the USCIS has released a visa bulletin. And the priority date for filing the adjustment of status, the EB-3 for Indian nationals is way ahead than compared to the EB-2. And that's kind of very odd scenario that ever happened in the preceding 25 years that I've been practicing immigration law. But we do expect that the EB-3 is going to be more forward than that of the EB-2 because the number of applicants that are pending in EB-2 are way longer than EB-3. That's the reason why we have noticed that the priority date has moved forward for EB-3 to EB-2. Now the question that pops up is that for those people who are in EB-3, do you advise them to convert into for those people who are in EB-2, do you advise them to convert into EB-2? I'm sorry, EB-3, sorry.
So if you are in EB-2, should you downgrade to EB-3? So for the last 15, 20 years, we've talked about upgrading from EB-3 to EB-2. Now is the first time we may have a potential for a downgrade to be beneficial. So do you think people who are currently in EB-2, everybody should downgrade? What's the process to downgrade, and when do you advise people to actually take that step? If
their priority date is current in EB-3, and it's not current in EB-2, they should be the persons who should be downgrading it to EB-3. Not all the people should be downgrading it to EB-3. Only those people whose priority date is current should be downgrading it to.
So those with the priority date really between May and October of
2009 right. should be downgrading it to EB-3. Now, when they downgrade from EB-3 to EB-2 to EB-3, they could file an I-140 application for EB-3, and they should be able to file the adjustment of status at the same time. They don't have to file an I-140. They don't have to wait for the approval of the I-140. They should just file an I-140 and adjustment of status at the same time. They don't have to wait for the I-140 approval.
And I want to point out that this should only be done as of right now in the month of October 2018, not after. Because the only place where EB-3 is more advanced than EB-2 is in the filing dates chart, not the final action dates chart. And you can only use the filing dates chart in the month of October. So we've had these dual charts going back to November 2015, but do you know how many times we've actually been able to use the filing dates chart?
Only in October.
5 months total.
Right.
I went back all 3 years, and there's only been 5 situations where we've been able to use the filing dates chart, and we haven't been able to use it since October of 2016. So in 2017, we were not allowed to use it, and I expect that we won't be able to use it again after October 2018 until potentially October 2019. That's when they allow us to use it, is at the very beginning of a fiscal year. So if your date is current in EB-3, but you're currently in EB-2, you have to act quickly and file this I-140 and 485
at the same time.
Only next month. You've got to get it done in October only. Don't expect that you'll have the same ability to use that filing date chart in
November. Yeah, it could not be. Most probably it won't be. So this is the right time for those people whose priority date is between May of 2009 and October of 2009 to file an I-140 and adjustment of status. As you know, Emily, that the priority date is backlogged from 2009. That's almost 9 years. And the way that the priority date looks to be moving is that for those people who are going to file a green card application, it doesn't look they will ever get the green card, because in 2007 it was 2007. In 2018 it's 2009. 2 years and 10 years, and sometimes even get back to 2007. Is there anything in the pipeline, either with the administration or with the Congress, to reduce the timeline for the Indian nationals and Chinese nationals for the employment-based immigration?
Yeah, we actually have two things going on right now, very positive action happening. So we've talked a lot about HR 392, which is the House version of the bill that would eliminate the per country cap. So HR 392, you all know, it's got tons of co-sponsors, lots of action happening on the sponsoring side, zero action happening on the actual bill itself being moved to the committee for debate and then moving to the floor. None of that's happened. That being said, it was added as an amendment into the spending bill. I honestly don't know what the status of the spending bill is, but that bill would have to be, go through the Senate with that same amendment being included, and then once it's passed, the president would have to sign it into law with that amendment in there. So that's the status of HR 392. At the same time, we have the Senate bill, S-281, which was introduced back in January, I believe, but no action has been taken on it, the Senate side. Now, within the last month, all of a sudden we've got 7 new co-sponsors to the Senate bill. So even if we don't see action happening in the spending bill, the Senate does seem to be adding co-sponsors to the Senate side of the bill, not the spending bill, but the actual S-281.
Right.
So maybe we'll see some action taken on either the Senate or the House side. Again, none of this has gone to committee yet. None of it's gone to the floor for debate. So it's at the very early stages, but the fact that we're seeing co-sponsors may be a good sign. At the same time, we have the I-2 Act, the Innovation and Immigration Act of 2018. So this was initially put forth by Senator Hatch time and time again, I think since probably 2010, maybe even 2007.
He's one of the most favorite guy for the IT sector, who understand the IT sector much better than anybody else, according to my knowledge, in the Senate.
So he proposed this bill, the I-2 Act, as they've called it, and it's kind of just languished in the Senate. No action has been taken, but all of a sudden last week we have a House version of the bill being brought by Representative Kaufman and Krishnamurthy. So this I-2 Act, the Immigration Innovation Act of 2018, goes so far beyond what HR 392 or S-281 would do. It is so, it's not comprehensive immigration reform, but for an employment-based immigration, it is a huge deal. So what are the highlights of this bill, Emily? So number one, it allows the recapture of green cards that went unused for
from 1992 to 2003.
Right. So,
which is approximately 250,000 green cards that were wasted, because back in those days, the per country quota limit, even if there is no other country people, they cannot use the countries that are using 7% cannot use, even if other countries were not using. That's the time those 250,000 green cards were being wasted. So you're telling that they want to bring back those 250,000 green cards and give it to the individuals.
Right. So they're trying to eliminate the backlog by using old green cards that went to waste. On top of that, they want to no longer count dependents towards the number of green cards being used. So as you know, for every worker who's sponsored, they generally have at least a spouse and a kid coming along with them, and those are counted against the
140,000 green card allowed.
Yeah.
So it's practically only 60,000 that's allowed for the entire
Right. So we may
green card.
actually triple the number of green cards available for the workers by not counting the spouses. On top of that, they want to not count certain people in the cap, such
STEM
as
degree.
the EB-1, A, and B, U.S. STEM degree, master's degree holders. They want to not count
So if
them.
somebody gets a Nobel Prize, for example, they are qualified under EB-1, which is actually backlogged by about 6 years right now. So
Right.
in other words, he doesn't want these Nobel Prize award winners to be counted towards the number.
Yep. It includes work authorization for spouses of H-1B holders that are waiting in the backlog, so we wouldn't need the H-4 EAD
EAD as a
anymore.
regulation.
It would actually be statutory. And then they would modify how the H-1B lottery is conducted, so it prioritizes PhD holders, U.S. STEM master's holders above other categories, eliminates from the H-1B cap U.S. STEM degree holders. So there's a lot in this bill, and also provides for dual intent for F1 students, so they can go straight from being an F1 student to a green card holder.
I think so, only for the
H-1B.
STEM degree F1 students.
That
The last time.
yeah.
Last time I read it was like, yeah.
And then on top of that, it actually creates kind of a special conditional green card for certain people that doesn't require them to go through the H-1B process. Depends on salary, depends on the type of job, and that sort of thing. So there's a lot in this bill that would solve a lot of the current employment-based green card issues, even if S-281 doesn't go through or H.R. 392 doesn't go through. Now, I'm not suggesting to not push for those. I think both should be promoted.
Complemented and promoted.
Yeah.
If this bill goes through, Emily, I think so a lot of jobs that are going outside the country because of non-availability of the STEM graduates will come to USA. Most of the jobs that are being created outside the country because of the immigration rules will be coming back to USA if this bill goes through. Emily, on the update of the student visa people, as you know that the F1 student visa people whose OPT or STEM extension is expiring in between April to October of 2018, if their H-1B is selected in the lottery, they are allowed to work on a cap gap until the H-1B is adjudicated or September 30th, whichever is later. What are the options for these people if the H-1B is still pending on or after September 30th? What are the options? What should they do? Can they continue working? Should they leave the country, or what are the options?
Yeah, definitely the cap gap ends September 30th. That's in the regulations. There's no extension of it possible. So your cap gap automatically ends September 30th. From that point, if you take no action, you'll move into your 60-day grace period of your F1 stay. After the 60-day grace period, so we're talking after November 30th, if you've still done nothing, yes, you can continue to stay in the U.S. based on your pending H-1B change of status request, as long as it's pending. Now, if the H-1B change of status gets approved, everything's fine. You just start your H-1B that next day. The problem comes in if the H-1B ultimately gets denied. So if you've taken no action after September 30th with regard to your current status, and your H-1B ultimately gets denied after the grace period ends on November 30th, the day of the denial, the next day, you're immediately out of status and you're immediately accruing unlawful presence. So that is a huge risk you're taking by not doing anything related to your status. Now, if you feel comfortable that your H-1B is going to get approved, certainly you are authorized to stay in the country and not work from September 30th until the date the H-1B is approved. But it is a big risk for those that maybe have a weaker case, or you know that an RFE has already been issued and hasn't been responded to yet. Most likely the processing time could go beyond November 30th, so you need to consider what your backup action is going to be. During the 60-day grace period, from October 1st through November 30th, you have the option of enrolling in a new course of study to continue your F1 stay. You have the option of changing status to any other type of visa you may qualify for. Most commonly would be an H4 if you're married and your spouse is already on H1.
They can always move into another university, continuing on the F1 visa. And if they do continue on an F1 visa, switching the service system to another university, that would not be a hindrance in getting the H1B adjudicated.
Right, yeah, I get that question a lot.
Yeah.
That, if I update my SEVIS record, what's that going to do to my H1B?
Right.
Absolutely nothing. The H1B is a separate process. The change of status is dependent on you maintaining your F1 status up through October 1st or through September 30th, but by getting a new program, getting a new I-20, that is not going to have any negative impact on the H1B process going on.
Emily, I want to go to some of the live questions that we're getting on here. Since the premium processing is suspended now, if the EAD is pending for the H4 EAD, can they continue working after the EAD expires, or they have to stop working?
That's a good question, and unfortunately, you have to stop working. There is no grace period or no automatic extension of an H4 EAD. Once the H4 EAD card has expired, if you don't have the new one in your hand, you have to stop working. There's no option there.
Can you also update on the H4 EAD? The administration has pointed out that they may take the EAD off for the H4 EAD. Have they taken it off, or where is it in the pipeline? What's the story about it? And if they would take it off, what do you think would be consequences?
Yeah, so we're definitely headed down that path. Now, interestingly, last week, the group of U.S. workers that brought the lawsuit that eventually is leading to the potential for rescinding the H4 EAD rule filed a motion in the court basically saying, hey, USCIS is taking too long to propose this rule. We don't even know what the rule is going to be. We're sick of waiting. We want the court to make the decision. So you may recall that this litigation's been going on for years. It's at the appeal stage. Right when the Trump administration came in, the appeal was filed, and the Trump administration came back and said, hey, we need time to figure out what we're planning to do, so please hold the case. And the court agreed, so they held the case for, I think, 60 days to give the Trump administration time to decide what to do. In the meantime, we have the Buy American, Hire American executive order that's telling all of the agencies to look through your existing regulations and see what needs to be modified, see if anything needs to be changed. So then the Trump administration came back to the court after that abeyance and asked for another abeyance of 6 months because they were thinking about proposing a new regulation. So since then, the case continues to be put on hold, on hold, on hold. The Trump administration keeps giving these 90-day status updates to the court, letting them know what's going on with the regulation. But really, their responses are very vague. They're just saying we're working on it without saying what it is or when they might have it. We had the Unified Agenda back in December said they were going to be proposing this regulation in June. It's now September, still don't have a proposal. So because of all the delays, the workers union wants the court to just actually hear the appeal case and make a decision on whether Homeland Security was ever actually authorized to give employment authorization to H4 holders when Congress said, no, you can't work. So that's what the whole case is based on, is whether Homeland Security, an agency, is authorized to give employment authorization when Congress didn't do it. So now I'm expecting the Trump administration will submit their brief in response to that motion, claiming, no, we're working on it, and then it'll be up to the court to decide whether they're going to continue to wait or actually move forward with the case. As of today, I don't think anything has been submitted to OMB yet, so it's still going to be at least a couple of months before we actually see a proposed regulation.
A lot of questions are coming. What how to downgrade from EB-2 to EB-3. Is my company and am I eligible to downgrade from EB-2 to EB-3? To downgrade from EB-2 to EB-3, you don't need to file another labor certification. You can use the same labor certification that you have for EB-2 and file a fresh I-140 application to downgrade into EB-3. Now, if it was vice versa, if it's an EB-3 labor certification, you want to convert into EB-2. In 99% of the time, you have to file a labor certification and then you have to file an upgrade to EB-2. But when we were downgrading from EB-2 to EB-3, we can use the same old labor certification and we can convert into EB-3 without any problem. Now there are a lot of questions. Well, the labor certification is only valid for 180 days. You cannot use the labor certification. Well, you're right in a sense, but there is an exception to that. If an I-140 has been filed based on that labor certification, that 180-day rule is not applicable. In other words, we can use the labor certification perpetually. So is there any circumstances, Emily, that you can think where we cannot file EB-3 using the same labor certification that we have used for EB-2?
I don't think so.
Yeah. I mean, exceptional ability, they don't file labor certification anyway. So, I mean, in every case, I think so. We cannot possibly think of anything where you cannot use the same labor certification to file from EB-2 to EB-3. Not at all. Now, if it's vice versa, from EB-3 to EB-2, no, you need to file most of the cases and upgrade labor certification.
All right, one of the questions we're getting quite a bit right now related to the premium processing suspension is, under what situation can I file my H-1 in premium processing? So we know that the only type of case USCIS will accept in premium are those that are filed in Nebraska, which is an extension with the same employer without change. Now everyone's asking, what does without change mean? And as far as I know, there's no guidance out there, so it kind of is up to the employer and their attorney to decide how much risk they're willing to take and try filing something as an extension without change. There are many situations where even if there's a slight change, if it's something that's not material, it's not really that important to the adjudication of the case, we might still be able to file it as an extension without change. Like, for example, say that the salary on the last petition that was filed is $80,000 and now it's $82,000. I would probably file that as an extension without change because the only thing that's changed is a slight difference in salary. Assuming work location is the same, job title is the same, SOC code's the same, job duties are the same. A slight change in salary to me is not worth calling it an extension with change. Now, what other scenarios are there that might count is really going to be a discussion that needs to be had between the employer and the attorney on each individual case to figure out whether it's safe to file it as an extension without change or not. I can't give a blanket answer to that, and I want to make sure that people are able to continue filing as an extension without change in lots of different circumstances. I don't want USCIS to cut us off on that issue. So definitely.
One other question that came out for the EB-3 downgrading. Can you file in premium processing for EB-3 I-140? I would advise against filing an EB-3 downgrade in premium processing. There are a couple of different reasons though. One is that if you file an I-140 and 485 together, if the I-140 is rejected, they will reject the 485. Now the reason why the clerks, not the officer, the clerks might reject the entire I-140 application when you file the downgrading and premium processing is because there is no original labor certification when you are trying to downgrade from EB-2 to EB-3. When they don't see the original labor certification, they might summarily reject that application. And by the time it comes to the lawyer's office and we communicate and we try to file it again, if we cross October, you will be in a big loss. What I would suggest you to do is to file an I-140 and to file the adjustment of status at the same time, get the receipt notice of the I-140, then you can convert that into premium processing and see how your luck goes. Even though you don't have the original I-140 labor certification with the file, the USCIS might consider it because they have the original I-1 labor certification with them, because you filed that original labor certification when you filed the EB-2 application. So at this point of time, I wouldn't advise people to file an I-140 premium processing if they are trying to downgrade it.
All right, Avinash has a question that's coming up quite a bit, again, with the premium processing suspension for transfers. If you are filing a transfer, now it's going to be in regular processing. Is it safe to join the new company based on the receipt? And what happens if they've joined the new company and then you get a denial of the H-1B transfer? So I think that, even though there's no premium processing, yes, technically you can still join the new company based on the receipt. That's under AC-21. Nothing has changed with your ability to do that. But how safe it is another story. If your I-94 from your current approval is still valid for some time, and then you file the transfer and join the new company and get a denial, at the time you get the denial, if your I-94 is not expired, yes, the denial puts you out of status, but there should be no unlawful presence in that situation because you've not overstayed your previously given I-94. Now, what can you do in that situation? Maybe you could try to make the argument that the 60-day grace period for H-1Bs starts from the date of the denial to allow you to file another transfer, refile the same transfer with the same employer. It's going to be some creative arguments to do that. We don't have any guarantees that yes, they'll accept those arguments or no, they won't. It's going to be up to the individual officer based on how well an argument is made there. So yes, there is some added risk to transferring and actually joining the new company based on the receipt. I think it really depends on the situation and why you're transferring. If you're going to be losing your current job, you probably don't have a choice. But if you're taking a new job, maybe see if they're willing to wait for the approval or delay the offer until premium is available. If that's not an option, then just be aware of the potential for a denial. Be careful about the company that you're transferring to. Make sure that they're filing all of the necessary documents. Make sure it is a good company that's gotten approvals before and is familiar with the process. I wouldn't necessarily want to risk my status for a company that I'm not 100% sure is going to get an approval. Now, of course, there's no guarantees that anyone will get an approval, but there are certain companies that I think have better chance of approval than others, and I would try to
One major question that pops up, Emily, is that you're telling that, yeah, it's reasonable for the employees to join, but I'm addressing the August 9th memo, which says that that if a person has violated the status for 180 days, they have a 3-year bar. And if the person has violated the status for 1 year, there's a 306, 1 year, there is a 10-year bar. If the H-1B transfer get denied, will the period of unlawful stay count from the denial date or from the time the transfer application has been filed?
Assuming that the I-94 has expired at the time of the denial, so it was valid at the time of the transfer and then expired while the process transfer was pending, the guidance from USCIS on that is pretty clear that unlawful presence only begins from the day following the decision of the denial.
That's right.
It doesn't go back to when your I-94 expired, as long as it wasn't a frivolous filing and the transfer was timely filed while your I-94 remained valid. That's what a period of authorized stay means. It means it tolls unlawful presence while the application is pending. So I think that even if you have a long pending transfer that ultimately gets denied, as long as it was not a frivolous filing and it was timely filed, the unlawful presence won't begin to accrue until the denial actually occurs.
That brings me to the August 9th memo, Emily. You said that the unlawful presence will start from the day of denial. What if that in the same scenario, the person is working on a CPT after he completes his OPT, after he completes his STEM extension? Now he joins another university, not for the purpose of studying, but for the purpose of getting a work authorization, and now the USCIS is cracking on that. If they get a denial, the unlawful presence, when does it start? On the day of denial?
Right. In that situation, unlawful presence under the August 9th memo begins from August 9th or the day the violation began, whichever is later. And that's different. So this is student visas, F1. The unlawful presence memo applies only to students in F, J, and M status. It does not apply to H1s. H1s has its own separate rules where unlawful presence doesn't begin until after a denial occurs. F1's unlawful presence, if a violation of status is found while you're in the F1 status, unlawful presence begins from the day the violation began, not the day of the decision that a violation occurred.
I know that you're the perfect person to answer this question, Emily. As we are noticing, this question comes from Ashwin. As we are noticing that the H-1B is under strict scrutiny, particularly if they do not have the degrees in computer science when they're working in a computer science field. What are the precautions for those people who are filing H-1B extensions, transfers, that have degrees in mechanical engineering or industrial engineering or civil engineering that they need to do? Now, this didn't used to be a problem mostly in 2016, but it has become a big problem. Even for those people who have worked for 10 years on H-1B, it has become a problem. What is the solution for this?
Yeah, remember we have the no more deference to prior adjudications, meaning that just because you got approved last time doesn't mean your degree and your qualifications will be approved this time around. So if there is a mismatch between your field of study and what is required by the job, one way to overcome that is to now get an education plus experience evaluation that says the combination of your education plus experience is equivalent to a degree in the field that matches what the job requires. So if we're talking about a difference between, say the job is normally requiring a degree in computer science, your degree is in mechanical engineering, but you've got 10 years of experience, you can combine your mechanical engineering degree plus your 10 years of experience to get the equivalent of a degree in computer science or something closely related, maybe MIS or something like that, and use that to qualify for the H-1B. So you can, if you know you're in that situation, I would probably get the education plus experience evaluation before I file and include it with the filing, because we do now have the RFE memo that says that if you don't submit a required piece of initial evidence, they can deny without an RFE. In the instructions, it lists education documents as part of the required initial evidence, so I would make sure I'm including that evaluation at the time of filing rather than risking a denial flat out.
The question that came is, what is the better place for the children to be born? If the parents are here in the United States, is it better for them to go to India to have the baby born there and come back, or is it better for them to have the baby born here? If you're on a non-immigrant visa and you are going to have a baby, I would strongly recommend that you have the baby here in United States. I'm a lawyer in both the countries, in India and also in United States. Now, if your baby is born in United States, the baby is going to be a US citizen. And once the baby is going to be US citizen, they have all rights. They can be the president of this country. They can have all the options. They won't be our clients. They don't have to watch this video. Now, if they are born back in your home country, you have to get them a dependent visa to come into United States. And then you have to file their extensions, and they have to go through the process. I have had some teachers who came in 15 years ago and they didn't got their H-1B, and their kids are born in India, and once they become 21, they have to move out of the H-4 and they have to apply for F-1 visa, and the green card process is going to take ever for them to get in. So it's not a good idea to have a baby born in India when you have an option. You're a non-immigrant visa, it's better to have the baby here. You can avoid us. I mean, that's a great thing. Before I became an immigration lawyer, I was a client of an immigration client. I don't want to be the client of an immigration lawyer if I can avoid it. So in this case, you can avoid your baby to be a client of an immigration lawyer. Why not take the advantage?
All right, I want to talk about the online case status system for a few minutes here. One question I get a lot from people on immigrationgirl.com is I put in my receipt number and I get this validation error or verification error. They couldn't find my receipt number in the system. That's completely normal. That right now there's a high volume of filing, especially through that September 11th, the premium processing deadline. So I think between the April H-1B cap filings and then all these premium processing filings, the data entry required to get everything into the system gets delayed. It takes longer. So it might take 30 days before your receipt number will actually work in the online case status system. So it's nothing to be concerned about. It doesn't mean there's not processing your case or there's something wrong with your case. It's just it takes time for them to get all of that into the system and for it to work. On another note, those that do have the system working, they're always getting these updates saying my name was updated in the system. Well, I never contacted USCIS and updated my name. My employer never did that. Why are they saying my name was updated? I get this question so many times. I actually wrote an article about it on my blog. So if you go to immigrationgirl.com and do a search for name was updated, you'll find the article. But I'll give you the short answer here. Basically, if you're seeing that, it means for some reason when the data entry was initially done that takes the information in your paper filing and puts it into the computer, maybe there was a typo in your name. And when the officer's actually looking at your case, they caught the typo and now they updated the name. And when they hit update, it automatically sends it to that case update system that tells someone that your name has been updated. So it doesn't mean you updated your name or your employer updated your name. It just means it's internally something was updated in your record, probably to correct an error or a typo, and it just gives that kind of
I would also like to
update.
add a couple of other things why the name change is occurring. When your employer or when your lawyer is contacting the USCIS to check on your case, they are sending a letter to us saying that we have updated the name. It doesn't mean they updated your name. We have also noticed that in cases where, Emily, when they are assigning the case to an officer, that name change is coming too. Mm-hmm. So when your case sits there, when the time comes to have an officer to take a look into it, when they take a look into it, the system will update saying that the name has changed. So I don't think so you should be fearing about the name change. Also, Emily, I noticed that this year as compared to the previous 4 to 5 years, the error validation is much more higher. I would say about 7 to 10 times higher than the previous years. In our own cases where we have our own receipt notices, we have noticed it. So if I were you guys, you are getting that validation error, I wouldn't be worried that much.
All right, here's another question on the validity of an I-140 approval from a previous employer. So we have the January 2017 regulation that was meant to improve job mobility for high-skilled workers. and it included a provision about when you can continue to use an old employer's I-140 to get H-1B extensions with a new employer. So in what situation can you not use the old I-140?
If the old I-140 was being revoked for fraud, then you cannot use that priority date to use it. If the I-140 has been withdrawn within 180 days from the time your I-140 has been approved, you cannot use the priority date. If the I-140 was being withdrawn before January 17th of 2017, irrespective of how long the I-140 has been approved, you cannot use the priority date. So those are the three circumstances that I can see the I-140 cannot be used. So in other words, if the I-140 has been approved and if it's not been withdrawn before January 17th and it's not been withdrawn within 180 days after it's been approved, that I-140 priority date belongs to you. You can use that I-140 for extending the H-1B with different companies. It doesn't have to be the same company that filed an I-140. It can be company B, then you want to move to company B to company C. You can keep using the same I-140 approval. And also you can use the same I-140 approval for filing an H-4 EAD even if you are not working for the same company. There are a lot of advantages if you let the I-140 to be there and it's not being withdrawn before 180 days. That has a lot of advantages. One is to retain the priority date, to file the H-1B extension, to file for the H-4 EAD. The only time where you would require your new company, if the 180-day rule has passed, is that when you want to actually get the green card, which it's taking approximately 100 years nowadays for those people who filed recently to get the green card. If you were to get the green card through that I-140, you need the new company to file upon an I-140.
All right, one of the live questions is, if I have an extension pending for my H-1B, can I now file a transfer? And the answer is, it depends on whether your current H-1B has already expired or not. If your underlying petition has not yet expired, absolutely you can file a transfer to the new employer. If that H-1B has already expired and your current status is based on the pending extension, you're not actually in H-1B status at that time. You're in a period of authorized stay based on the pending extension. So while technically, yes, you can file a transfer to the new employer, that extension becomes a bridge between your old approval and the new filing of the transfer. When you transfer to that new employer, it is very likely that the last employer is going to withdraw that pending extension. When they withdraw that, or maybe it gets denied, your bridge collapses, meaning that now there's been a gap from the end of your I-94 to the filing of the transfer, meaning your transfer is likely to get approved without an I-94. And you've been out of status since the denial of the extension or from the withdrawal of the extension, and that's a very risky situation to be in. So after your I-94 is expired, it is rather risky to file a transfer to a new employer while your extension is still pending.
I think so. That's it, Emily. You have any more questions that you want to answer?
Just a quick update on the processing of H-1Bs and the CAP. A lot of people are asking, are they getting approvals after an RFE has been responded to? Yes, we are seeing approvals from the cases where we responded to an RFE anywhere from 30 to 60 days ago. We're starting to get those approvals now. So if you've responded to your RFE recently, you can expect probably close to 60 days before you get a result of that. They are taking a while, but they are issuing the decisions after the RFE was responded to.
One of the other things is that I have filed the H-1B in the quota and have not received the RFE or the approval. Am I in trouble? Is there something wrong? No, you're fine. You don't have any problem. That's normal nowadays. Approximately around 33% of the cases that were being filed, we have not received an RFE or a approval at this point of time. So you're good to go in that.
Yeah, just if you're in F1 status and there's any potential for a determination that you violated your F1 status, maybe for using CPT incorrectly, even if the H-1B is pending, keep February in mind. If you don't have an answer by February, you may still want to plan on exiting the country, because you don't want to end up in March with a denial of a change of status due to a status violation. That is going to take effect from August 9th. Now you've crossed 180 days of unlawful presence under the August 9th menu. Yeah, exactly. So lots to be careful of if you're in F1 and your H1 is going into February. Keep in mind.
Yeah, anybody who is on student visa, you file the H-1B and their H-1B is not getting adjudicated in February, I think so they should be very well alert to make sure that they don't cross the 180 days assembly.
All right, well, thank you for joining us today. Again, if we didn't get to your question or you want further information, you can always set up a consultation by going to rnlawgroup.com. You can subscribe to my updates at immigrationgirl.com. Follow us on Twitter at rnlawgroup or at immigrationgirl, and join us again next week.
Thank you.